All right, today I'm here with my personal attorney, Kyle Brown, and I'm often asked questions about putting your home in a trust or in a will or so forth. And so we wanted to give you some information today to start with. What is the difference between a will and a trust?
Well, the primary difference, both documents, you're dictating your wishes as to what you want your assets or whether you want your assets to go when you pass away. But the main difference, and I tell clients this every day, is, and this is a big misnomer, people don't realize this, a will is perfectly valid as long as it's validly executed, and it will be enforceable as long as it's valid. But it just directs who your assets go to, but it does not avoid probate, okay? A trust avoids probate. And that's one of the main two reasons I tell people if you want to do a trust or consider doing a trust is, one, to avoid probate, and we can talk about that, and two, is it provides a mechanism for the money to be managed. And if you have like minor children or young adults and you want that money to be managed by, say, another family member or financial advisor.
So just for clarification for me, I think I know the answer to this, but just to be sure. So say in my will, like for instance, my son is now 21, so I don't need to dictate who would have his care after I were to pass away. But those kind of instructions were in my will.
Absolutely.
Prior to him being 18. So it was more like directions on how to handle things when I passed away, whereas the trust really just dealt with all of my assets and how that would be handled.
And that's true. What you're talking about is naming a guardian for a son. That you don't need a guardian anymore after their 18th birthday.
Right.
And that is absolutely correct. Guardians are always designated in the will itself as opposed to the trust. And the trust just basically is a separate legal entity that owns assets that says, you know, in the event of your disability or death, what happens to those assets, who manages them, and who are they ultimately distributed to. But yes, guardians are always referenced in the will.
Okay. And also, like, if I had some, I mean, I don't, but if I had some like amazing piece of jewelry or some personal property item that I wanted left to somebody, I would give those instructions in a will, or would that also be in a trust?
Well, most attorneys would do the same thing, but our documents, our will and our trust, both have essentially a paragraph that says, if I leave a memorandum that dictates how I want certain tangible personal property to be distributed, we actually give our clients a blank memorandum, and it has a column for who gets the item and the column of describing the item. But basically it says, to the extent that I prepare such a memorandum that says, I want my diamond necklace to go to my sister or whatever, that document has legal effect. And so that doesn't necessarily have to be done with a lawyer. We give those forms to clients as a blank form to fill out on their own time. And then that way they don't have to come back to a lawyer as their personal property changes over the course of their life. They can, rip it up and do it on their own. And, they would have their own form to completely do that.
Okay. Sounds good. So will is more like my personal wishes and taking care of my kid if he or she is below the age of 18, and trust is really more like the big assets.
So just to reemphasize the fact that the main difference between a will and a trust is a will does not avoid probate, but a trust would.
Okay. We all know we want to avoid probate.
Yeah, and probate's just expensive and
Yeah.
takes 6 months to a year, and you can avoid all that by just setting up a trust, putting all of your assets in the trust, and then it just makes the administration and the distribution of your assets after your death so much more easy. If you do a trust, then typically all you need at the title company when you're selling the house would just need either a copy of the trust itself, or usually a better method is to give them a certificate of trust, and that's all they need. And so when they're signing the title paperwork, basically they're signing, Holly, instead of Holly individually, it's Holly as trustee of the Henbest Trust, basically. So that's the only difference, makes it easy peasy.
Okay. Awesome. All right. Well, thank you.
Okay. You're welcome.